on the 25th of April, 2018, whereby it claimed against the defendant the relief set out as follows. 1. The sum of 5,996,817 naira 59 kobo only, being balance of the money paid by the claimant to the defendant by the claimant's account number 2022791388 with the United Bank of Africa PLC for sponsorship of defendant's international training, which sponsor he was no longer entitled to due to his removal from office of the claimant. B, interest rate at 10% per annum on the sum of the said 5,996,817 naira, 807 naira 59 kobo from 11th of August 2014 till judgment sum is finally liquidated. And C, the cost of filing the suit. The defendants joined issues with the claimant by filing a statement of defense on the 4th of July 2019. The defendant contended in summary that the application for sponsorship of his PhD was made to TET Fund, and that the money released by the claimant to cover his studies was from TET Fund and not the claimant. The defendant further contended that he was not given fair hearing on the allegation of misconduct. The defendant also contended that the bond he executed with the defendant for study fellowship did not contain any condition or covenant requiring the refund of the sponsorship fund. The claimant filed a reply to the statement of defense on the 18th of July 2019. At the plenary trial, Ahmed Tijani Ibrahim, the bossa of the claimant, testified as a sole witness. He adopted a statement on oath as his oral testimony and further tendered 16 sets of documents as exhibits to further substantiate the claimant's case. He was thereafter cross-examined by the defendant's learned counsel. As I had earlier noted, the defendant filed a statement of defense. Excuse me. And a statement on oath, but elected to rest his case on that of the claimant. Thereafter, parties filed and exchanged their written final addresses as prescribed by the provisions of Order 45 of the rules of this court. In the address filed on behalf of the claimant on the 19th of November 2020, and settled by MB Tanko Esquire of counsel for the claimant, a sole issue was canvassed as having a reason for determination in the suit, that is, whether or not the claimant has proved its case to be entitled to the judgments as per the claims. In the final address filed on behalf of the defendant on the 9th of December 2020, his learned counsel, Maxwell Kearn Esquire, identified two issues as having a reason for determination in the suit, namely, 1, whether this court is clothed with the requisite jurisdiction to entertain the suit, same having been initiated in this court via an improper process. 2, whether the claimant has established its case to warrant the grant of the relief sought in its favor. The claimant's reply on points of law to the defendant's written address was filed on the 15th of December 2020. I have painstakingly examined the totality of the pleadings filed by both parties in contention, the totality of the admissible and relevant evidence adduced at the trial, and the written addresses and oral submissions of learned gentlemen for the two parties. My view is that two issues call for determination in this suit. without prejudice to the other issues formulated for determination by the respective learned counsel, I shall proceed to determine the suit on the basis of the issues set out as follows. 1. What was the extent of the defendant's obligation under the bond agreement? 2. Considering the facts and evidence admissible in this case, is the claimant entitled to the relief sought? It is obvious from the learned counsel for the defendant's written address that the first issue distilled by him is a jurisdictional issue. Excuse me. It is premised on the ground that the process adopted by the claimant in initiating the suit was improper, and the court is urged to strike out the case for want of jurisdiction. It is settled that the issue of jurisdiction is fundamental to the question of the competence of the court adjudicating. This is the reason the issue of jurisdiction takes precedent over all other issues whenever it arises. See the cases of Iwuji and others versus Governor of Imo State and others. The case of Dangote General Textile Products and others Limited versus Ascon Associates Nigeria Limited and another. Citations supplied. Permits me to also quickly affirm the tried position of the law that in order to determine whether or not a court can exercise jurisdiction over a matter, it is the facts averred in the complaint in statements of facts and the reliefs endorsed therein alone that the court is required to examine and no more. See the cases of FUMB Limited versus Aerobel Nigeria Limited, Moyosore versus Governor of Kwara State, Guinness Nigeria PLC versus SKA Nigeria Limited, citation all supplied. The grounds of the learned counsel for the defendant is that the provision of section 24(3) of the National Industrial Court Act is unconstitutional in that the National Assembly acted ultra vires by conferring additional powers on the courts and on the High Court of the states. Learned counsel for the defendant hinged his arguments principally on the ground that the National Assembly is not empowered to make law conferring additional power to the High Courts. Learned counsel thereby urged the courts to declare the provision of section 24 sub 3 of NICA unconstitutional and void to the extent of its inconsistency by virtue of section 1 sub 3 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Learned defendant's counsel further argument is that the Kaduna State House of Assembly has not enacted any law empowering the High Court of Kaduna to transfer cases to National Industrial Court, and as such, the High Court of Kaduna lacks the power under the provision of section 24 sub 3 to transfer this to this honorable court. Learned counsel argued further that the order of transfer of the present case made by Honorable Justice Kurada of the High Court of Kaduna State to this honorable court is unconstitutional, null and void. Learned counsel finally urged the honorable court to set aside the order of High Court of Kaduna State transferring the instant case to this court. In support of his proposition, learned counsel cited inter alia the cases of Fashekin Foods Nigeria Limited versus Shosonya, Aquarido versus Petroleum Trading Institute, Alabi versus National Assembly, Wheat and Bush Limited versus Dell Power Systems PLC, citations all supplied. In reaction to the issue at hand, learned counsel for the claimants in his arguments distinguished between the judicial power vested in the courts under Section 6 of the Constitution Supra and the jurisdictional power vested in this honorable court under Section 2546 sub 1 of the Constitution as amended and Section 7 of NICA Supra. Learned claimants counsel further argued that by virtue of those provisions, this honorable court lacks the power to declare the provisions as unconstitutional. Learned counsel also argued the parties cannot, by connivance, acquiescence, or coalition, confer jurisdiction on a court. Now, the single issue in contention here is whether, by the provision of Section 24(3) of the National Industrial Court, the National Assembly acted ultra vires by conferring additional powers on the State High Court. To properly address this issue, it will be expedient to embark on a forage of the Constitution of the Federal Republic of Nigeria, Supra. Section 2, 1 and 2 of the Constitution provides, I quote, Nigeria is one indivisible and indissoluble sovereign state to be known as the Federal Republic of Nigeria. Nigeria shall be a federation consistent of states and a federal capital, end of quote. From the above provision, Nigeria operates a federal system of government. In modern terms, federalism is a system based upon democratic rules and institutions in which the power to govern is shared between the central and state provisional governments in accordance with the terms and conditions prescribed by the subsisting constitution. The legislative powers of the federal government of Nigeria, as well as the state government, are as prescribed in Section 4 of the Constitution, and for the purpose of the issue in contention, the relevant provision of the said section is herein below set out. I quote, the legislative powers of the Federal Republic of Nigeria shall be vested in a National Assembly for the Federation, which consists of a Senate and a House of Representatives. 2, the National Assembly shall have power to make law for the peace, order, and good government of the Federation or any part thereof, with respect to any matter included in the exclusive legislative list set out in Part 1 of the second schedule to the Constitution. 3, the power of the National Assembly to make laws for the peace, order, and good government of the Federation with respect to any matter included in the exclusive legislative list shall, save as otherwise provided in the Constitution, be to the exclusion of the House of Assembly of States. 4, in addition and without prejudice to the powers conferred by subsection 2 of the section, the National Assembly shall have power to make laws with respect to the following matters, that is to say, A, any matter in the concurrent legislative list set out in the first column of Part 2 of the second schedule to the Constitution to the extent prescribed in the second column opposite thereto, and B, any other matter with respect to which it is empowered to make laws in accordance with the provision of this Constitution. 5, if any law enacted by the House of Assembly of a state is inconsistent with any law validly made by the National Assembly, the law made by the National Assembly shall prevail and that other law shall, to the extent of the inconsistency, be void. End of quote. It is clear from the above provisions that the power to make laws for the peace, order, and good government of the Federation or any part thereof, with respect to matters included in the exclusive legislative list set out in Part 1 of the second schedule to the Constitution, is conferred on the National Assembly, and that the exercise of the power thereto shall be to the exclusion of the state houses of assembly. In addition, the National Assembly is also conferred with powers to make laws with regard to any matter in the concurrent legislative list as set out in the first column of Part 1 of the second schedule to the Constitution, and only to the extent prescribed therein. One point that clearly emerged from the provision of Section 4 of the Constitution supra is that the powers to make laws by each tier of government has been defined and listed in the schedules to the constitutions or as per any other provision, except, however, for the fact that under Section 4.5, where the law made by the House of Assembly is inconsistent with any law validly made by the National Assembly, the law made by the National Assembly shall prevail, and the other law shall, to the extent of the inconsistency, be void. See also the cases of AG of Federation versus AG Lagos State, the case of Osun State Independent Electoral Commission and another versus Action Congress and others, the case of AG Abia State versus AG of the Federation. Citations all supplied. Without belaboring the issue of inconsistency or unconstitutionality as argued by the Learned Defendants Council, the National Assembly has the power to make law for the Federation or any part thereof with respect to labor, including trade unions, industrial relations, as set out in Part 1 of the second schedule to the Constitution. In other words, the issue of inconsistency or unconstitutionality does not arise in the instant case, and I so hold. The further contention of the Learned Council for the defendants is that unlike the powers conferred on this honorable court pursuant to Section 24.3 NICA, the High Court of Kaduna State cannot exercise the power to transfer cases to this honorable court. Learned Counsel argued that the order of transfer made by Honorable Justice Kurada of the High Court of Kaduna State is unconstitutional, null, and void. I should note that in challenging the power of transfer of the case by the State High Court Kaduna State, the State High Court of Kaduna to this court, Learned Counsel failed to annex or exhibit the said ruling of Honorable Justice Kurada of the High Court of Kaduna State. Nevertheless, by a letter dated the 4th of December 2018, from the Honorable Acting Chief Judge of the High Court of Kaduna State, Honorable Justice Muhammad Lawal Bello, now the Honorable Chief Judge, this case was transferred to this honorable court. Now, the provision of Section 24 sub 3 of NICA Supra in contention provides as follows. I quote, notwithstanding anything to the contrary in any enactment on law, no cause or matter shall be struck out by the Federal High Court or the High Court of a state or of the Federal Capital Territory, Abuja, on the ground that such cause or matter was not brought in the appropriate courts in which it ought to have been brought. and the court before whom such cause or matter is brought may cause such cause or matter to be transferred to the appropriate judicial division of the court in accordance with such rules of court as may be in force in that High Court, or may under any enactment or law empowering the making of rules of court generally, which enactment or law shall by virtue of this subsection be deemed to include the power to make rules of court for the purposes of this section. End of quote. In the case of John versus Igbo Etiti Local Government Area, 2013, 7 Nigeria Weekly Law Report, part 1352 at page 1, it was interpreted that this provision was a directive to the Federal High Court and the High Court of the states not to strike out a matter where it finds out that it possesses no jurisdiction to entertain same, and that such Federal High Court or High Court should instead transfer the matter under its own rules of court to the National Industrial Court. This exercise of power of transfer of cases to the National Industrial Court by the Federal High Court or the High Court of a state or of the Federal Capital Territory, Abuja, is, however, not a free-for-all affair, as it is dependent on the High Court concerned possessing the power of transfer either under its High Court law or its rules of court. I should, however, remark that the above authority and the authorities of Fashakin Foods Nigeria Limited versus Shosanya Supra, and the case of Aquarido versus Petroleum Trading Institute Supra, and the case of Alabi versus National Assembly Supra, relied upon by the learned counsel for the defendants to convince this court that the state high courts or federal high courts cannot transfer cases to the National Industrial Court of Nigeria without the rules of the said courts no longer represents the current and correct position of the law on the issue. This is in view of the recent decision of the Apex Court in the case of Musa Ismaila Maigana versus Industrial Training Fund in SC Supreme Court /535/2004, delivered on the 18th of December 2020, where the Apex Court Paukoro JSC held as follows. I quote, "It is clear from the wordings of section 24(3) of NICA, the intention of the legislature is to preserve suits pending before the various federal and state high courts prior to the time the Third Alteration Act 2010 was passed into law. Section 22(2) of the Federal Act and section 24(3) of the NICA aimed at avoiding a miscarriage of justice to party who, after the commencing action before the Federal High Court or High Court of the State or Federal Capital Territory, will have its case thrown out after it were divested of jurisdiction to entertain the matter. It is perhaps significant to state, by reviewing the previous position of law as it relates to the provision of section 24(3) NICA on transferring of a suit by courts that lack jurisdiction to this honorable court, it is the view of this court that it is to prevent the untold hardship inherent in striking out of matters and the avoidance of miscarriage of justice that precipitated the current position for transfer of matters, albeit without the rules of such courts. I should also remark that from the contents of the letter of transfer of the Honorable Chief Judge of Kaduna State, excuse me, on the same reasoning, remitted the case filed to this Honorable Court. Therefore, being the most recent decision of the Apex Court on the interpretation of Section 24(3) Nica Supra, the contention by learned counsel for the defendant that the claimant's suit is unconstitutional and a nullity on the ground that the High Court of Kaduna State lacked the power of transfer no longer represent the current legal position. This case was properly transferred and was properly initiated, and I so hold. On the issue of setting aside the order of High Court of Kaduna State as urged by learned counsel for the defendant, and to restate the settled principle of law that ordinarily and except in certain defined and specified circumstances, no court of concurrent jurisdiction has the power to review or set aside an order made by another judge or court of concurrent jurisdiction. I cannot agree more, but with the submission of the learned counsel for the claimant, that the ruling of Kurada J of High Court of Kaduna State is still valid and subsisting. Certainly, I do not have the jurisdiction to interfere with the decision being a decision from a court of concurrent jurisdiction. Otherwise, it will amount to sitting on appeal, which the law does not allow. Without any much ado, therefore, this court is competent in law to exercise jurisdiction to entertain the suit, and I so further hold. Having dealt with the substance of the varying objections raised by the learned counsel for the defendant, the coast is now clear for the court to proceed to determine the substance of the claimant's case. Now, as I earlier stated, the defendant rested his case on the claimants. The legal implication of resting the case of the defense on that of the claimant is that where a defendant does not adduce evidence, the evidence before the court goes one way, leaving the court with no other evidence or sets of facts with which to do the measuring of the scale. In a situation as the present case, where the defendant leads no evidence in proof of the facts pleaded by him or rests his case on that of the claimant, such pleading is deemed abandoned. The defendant is deemed to have completely accepted both the pleadings and evidence or the case presented by the claimants. See the cases of UBN PLC versus Astral West African Limited, Aregbeshola versus Oyinlola, the case of Aodo versus Benioli, citations also applied. Having rested his case on that of the claimant, the defendant is deemed to have abandoned his case, and I so hold. The law, however, is the failure of the defendant to adduce evidence does not on its own translate to automatic victory for the claimant against the defendant. This is because a claimant must succeed on the strength of his case and not rely on the weakness of the defense. And the absence of a statement of defense or evidence by the defendant does not exonerate the responsibility on the claimant to prove his claim. See the cases of Aka Hair Services Limited versus Kenzo, Ogunya Day versus Oshunkaye citation supplied. I should at this juncture remark that the learned defense counsel in his written address made concerted attempts to give evidence for the defendant. It is trite that the address of counsel, no matter how brilliant, cannot be the substitute of evidence. Now, parties are adamant that the claimants granted approval for sponsorship of the defendant for international training for his PhD. that a bond was executed by parties and that the sum of 6,909,395 naira 25 kobo was credited by the claimants to the defendant's bank account. The application letter informs the bond form and the e-payment mandate and payment voucher were admitted in evidence as Exhibits C1, C2, and C3 respectively. To establish the claimant's case, the uncontroverted evidence of CW1 is that the defendant was involved in a case of examination misconduct about the same time the funds was released to the defendant's bank account. That a letter was immediately written to the defendant's bank, UBA PLC, to freeze his account. That at the conclusion of the investigation into the examination misconduct, the defendant was indicted and removed by the governing council of the claimant. That the defendant was no longer entitled to the funds upon his removal. That the claimant requested for the refund of the funds from the defendant, but the defendant stated in his reply that he was unable to withdraw from his account because his account has been frozen by the court upon the claimant's application. CW1 testified further that thereafter, the defendant obtained another court's order to unfreeze in his account and that he withdrew money from the account with a credit balance of 912,577 naira 66 kobo. CW1 also testified that the defendant's bank has paid the said sum of 912,577 naira 66 kobo to the claimants, leaving a balance of 5,999,099. Excuse me, I have to check that again. 5,909,996 naira 17 kobo. Exhibits C5, C6, C4, C7, and C8, the minutes of the 55th meeting of the Governing Council of the claimant, letter of removal of the defendant from office, claimant's letter of request to UBA to freeze or block the defendant's account, letter of defendants to the claimant, CTC of enrollment of court's order were admitted in evidence. CW1 testified further that the defendant challenged his dismissal, that his case was dismissed by the Honorable Court, and that his appeal was further dismissed by the Appellate Court. The CTC of the judgments of this Honorable Court and the Court of Appeal were admitted in evidence as Exhibits C10 and C9 respectively. Now, from the evidence on record, it is stating the obvious to affirm from the onset that the relationship between the claimant and the defendant is delimited by the bond agreement, that is Exhibit C3. The determination of the suit, in my view, will turn largely on the understanding of the purport of the obligations of the defendant, in particular, with reference with the bond for the study fellowship. I have taken a critical review of Exhibit C3, titled Bond Form for a study fellowship. The recital thereof reveals the intention of the defendant. It states as follows, I quote, whereas the member of staff has applied for and has been granted a study fellowship by the university to study in University of Putra, Malaysia, for the period of 1st August 2014 to 31st July 2019, 5 years, end of quote. The bond went further to state the details of the obligations of and expectations from the defendants with respect to the study fellowship and his entitlements during the study fellowship. It is an elementary principle of contract and indeed well settled that parties are generally bound by the terms and or conditions of an agreement which they voluntarily entered into. It is also tried and as correctly submitted by the learned counsel for the defendant that the courts are bound by the terms of an agreement which parties before it have freely and validly executed. Thus, if a court is called upon to construe an agreement, the court cannot but limit itself to the express terms of the agreement as indicated and or specified by the parties. This is because where the parties have embodied the terms of their contract in a written document, extrinsic evidence is not admissible to add, vary, subtract from, or contradict the written terms of the contracts of agreement. Therefore, where a court is faced with a task of interpreting a written instruction or agreement from one party to the other, or between two or more parties, as the case may be, it is expected that it will carry out its duty within the walls or confines of the written and express terms of the instruction or agreement. See the cases of Babatunde and another versus Bank of North Nigeria Limited and others, Chukwu and another versus Chukwu and others. Citations supplied. The task this honorable court is to undertake is to examine the terms of the bond fund as embodied in Exhibit C3, if by the terms or conditions therein, the defendant has an obligation to refund to the claimant the sponsorship fund, and if so, under what circumstances. From the totality of the testimony of the claimant's witness on record, it is clearly established through Exhibit C2 and C4 that the sum of 6,909,395 naira 25 kobo was paid into the defendant's UBA account on 18th of August 2014, being funds for the study fellowship. It is also an established fact by Exhibits C5 and C6 that the defendant was indicted and removed from office on the 23rd of April 2015, and that he challenged his dismissal both at this honorable court and at the appellate court. Learned Claimant's Counsel had hinged his argument strenuously so on his understanding of the claimant's obligation under the bond. Learned Counsel's interpretation is to the effect that the defendant must not be allowed to benefit from his wrong, having been dismissed from the claimant's employment for serious misconduct. Indeed, as correctly submitted by Learned Counsel for the claimant, it was held in Teriba versus Adeyemo, 2007, Law Pavilion Electronic Law Reports 3143, that by applicable equitable principles, I quote, a person cannot benefit from his own wrong, that it is adjudicatory function and the court has a duty to prevent injustice in any circumstance and avoid rendering a decision which enables a party to escape from his obligation under contract by his own wrongful act. End of quote. See also the case First Bank PLC versus Standard Polyplastic Industry Limited, the case of PDP versus Ezio Wuka and another. Learned Defendants Counsel argued that the understanding of the defendant's obligation under the bond is restricted only to the study fellowship, but not with respect to refund of the study fellowship funds that has been released before the defendant's employment was dismissed. In other words, the exercise of the defendant's obligation under the bond must relate strictly to the study fellowship by the defendant and no more. I totally agree with the submission of the Learned Defendants Counsel. I have carefully reviewed the entirety of the terms, clauses, and conditions agreed by parties in Exhibit C3. The obligations of the parties as outlined in the exhibit are simple and straightforward. No portion thereof contains any term or clause requiring the defendants to refund the funds of the study fellowship upon determination of his appointment with the claimant. My respective view is that the Learned Claimants Counsel's argument with respect of his interpretation and understanding of the defendant's obligations under the bond appears to be extensive and or beyond the walls or confines of the written and express terms of the bond. CW1, while answering questions under cross-examination, also testified that there was no document by the claimants to convey to the defendant that the bond had been terminated by reason of his dismissal from the claimant. It is rather sad that the defendant has eloped with almost 6 million and thus escaped responsibility, taking advantage of the law of the sanctity of contract. The circumstances of this case, and unfortunately so, the court's position in Teriba versus Adeyemo Supra cannot be invoked as this court, with the circumstances of the case, is limited to the express terms of the agreement as indicated and or specified by the parties in Exhibit C3. The defendant has no obligation under the contract to refund the sum under any circumstances, and so he cannot be said to have escaped his obligation under the contract by wrongful acts as alleged by the claimant. The result, therefore, is the claimant has thereby failed woefully to prove the claims and therefore not entitled to the refund of the money being claimed. I hereby resolve the two issues set down for determination against the claimants. The judgment of the court is that the claims of the claimants is lacking in merit and in substance. It shall be and is hereby, accordingly dismissed. Parties shall bear their respective costs. That is the judgment of the court.
Yes, we are most grateful of the judgment of this case. Thank you.
We are very grateful, my Lord, for a well thought out and a well delivered ruling, my Lord.
Thank you.
Thank you.
The judgments will be posted on the NICN portal by the end of today. You can have access to it.
You are most
You
grateful.
will have copies of a judgment when the JUSON strike is over, when you apply for it.
You are most
Thank
grateful.
you.
Thank you.
The court leaves the meeting. Thank you.
Have a wonderful day, my lord. I need to see this new judgment that was delivered.
Because that's judgment.
As at the time we were arguing this case,
It was not there.
it was not there.
It was not there.
The